Just to introduce myself, I know I've met quite a few of you over the last couple of years, but I'm Goddard. I am a professional support lawyer at Addleshaw, Goddard. So that means you won't see me on any transactional matters. You'll see me on training sessions like this, but I help the team in the background with know-how training, new law like this that's coming out, and sort of general queries. So I'm a kind of supporting but not transactional lawyer. But I'm always around and I'm always happy to be run up and ask queries, etc. Stacey kindly asked me to come along and talk to you about the Electronic Communications Code, which is a new piece of law which came into force on the 28th of December. So that was a fun Christmas, I have to say, reading through all of that. In terms of what we're going to cover today, I was asked to actually go over the old Electronic Communications Code, just to make you aware of what was out there, and therefore how, whilst there is a change, there's not a huge seismic change. I propose to kind of whip through that and then focus more slowly on the new Electronic Communications Code. But there are transitional provisions for subsisting agreements which are already in force, which is also why you need to understand the old code and a few practical issues to think about. Now, I have brought a pad with me and I have a pen. I can honestly say that I know already that people will ask me questions and I will not know the answer to it, but I'm perfectly prepared to take them down, look them up, go away. And because it's a piece of brand new law, there's no case law out there is no interpretation. We're kind of working a little bit in the dark on our best guess as to what we think will happen. If anybody has questions, feel free to shout them out while going along, keep it formal, don't have to wait to the end or anything like that. So, first thing I just wanted to think about in terms of the code. The code gives rights to people who are called operators. So the question is, who is an operator? Well, it's very easy. You can go into Google and go on to Google telecommunications operator underneath Ofcom website, and it will bring you up the link. And there's a list of companies which have been designated as operators under the Communications Act 2003. So if Ofcom has given them a designation, you know they're an operator. If they're an operator under the telecoms, and this is just telecoms, then they have all the rights that I'm about to tell you about. The question is, what happens if you're not dealing with an operator? I know there are some telecommunication companies which aren't operators for the purposes of the code. If you're not dealing with an operator, then you're not dealing with someone who has protection, okay? And you can essentially forget about everything we're talking about. However, a little word of caution, what you need to think about is negotiating with them agreements that they're not going to become an operator, that they have no intention to do that, and give those contractual obligations that they're not going to do that, and try and get the agreements terminated if they do actually become an operator, because you then want to re-agree an agreement that's a code agreement if they become an operator. So the next thing is we're talking about what kind of telecommunications company we're dealing with, what kind of property interests are we dealing with? Lease or wayleave is my first question, but it doesn't have to be only a lease or a wayleave that get protected. But two examples for you. You've got a tenant in a block, much like this, and the tenant needs broadband. So you've got a cable that will come in, possibly go over the landlord's land outside the building, maybe go up this end, or it might go up a riser in the middle of the building, through common parts, and then eventually end up in the tenant's parts. That's where we'd say that's probably a wayleave. So it's similar to an easement or a servitude if it's in Scotland, but you don't need dominant and servient land. So when you're granting an easement, you're thinking about a right of way, something like that. And for that to have effect and be binding on all parties, no matter who owns it, you need some land which is dominant and has the benefit of it, and you need some land which is servient and is the one that the right is going across. With a wayleave, there's no servient land, but there's no dominant land, it's the operator that has that right. So it's a contractual agreement. If you're looking at something like that, which is my artist's interpretation of telecommunications mast, then you're probably more looking at a lease, because you're actually demising an area for that mast to sit on. Okay? And telecoms leases are probably where there is more change that has happened under the new code, both in terms of the payments that can be made, assignability, etc. What I want to say though is you don't have to necessarily have a lease or a wayleave to be binded by the code. Once an operator has got communication apparatus on the land, they are going to be protected. So the minute apparatus is there and is down, there are processes that you've got to go through to get them off. Okay, they have a kind of super security tenure. So let's look at the old code powers. What happened under the old code? There was an agreement between the landowner or the occupier of land and the code operator. It could be a countersigned letter signed by the occupier. So actually, the freeholder didn't even need to be a party to that agreement. And the freeholder could be bound just by the tenant, say, entering into a supply agreement with an operator, and at that stage the freeholder was automatically bound and they couldn't do anything about it. The old code was quite narrow in what the rights it granted. It allowed you to do works, keep apparatus, enter to inspect, maintain, etc. If there was no agreement between the parties, then under the old code, the operator could come along, serve a notice requesting rights from the land. And that had to be in an Ofcom prescribed form manner. If there was no agreement from an occupier within 28 days, then they made an application to court. What could the court do? Well, they had to make an order in favour of the code operator, and it would bind anyone with an interest in the land. And they would have to make one if the damage could be compensated by money or the prejudice was outweighed by the benefits of those needing getting access to communications. So there was a very public policy element to it, which has been even widened in the new code. The court basically had to have regard to the principle of not unreasonably denying access to telecommunications equipment. So it was very likely if a code operator came along, had someone to serve or needed to put a mast up, that they would actually get those rights. In practice, operators didn't actually use their code rights that much. They usually negotiated and came to agreements, and they always had the code in the background as the stick to beat the landowner with if they couldn't come to agreement. So the question was, what happened when you wanted to redevelop? So in this situation, you got rid of your tenant, but you still have that cable there. You want to come along and you want to knock the building down. How did you force removal of the apparatus? Well, two things. I suspect in reality, nobody ever really did go through a process forcing removal of that apparatus. If there was a telecommunications mast on the roof, that might be a bit more difficult. There was just a cable there, I suspect. So I sort of talked about this. When has anybody actually terminated a wayleave? Once the cable is no longer serving any other property, the operators don't seem to be that interested in the apparatus. But if you needed to go through a process, what did you do? Well, there were two things. You could operate the lift and shift provisions in the old code, and then the alteration provisions. So anybody with an interest in land, or even adjacent land, could serve the notice requiring you to alter it, and it had to be necessary to carry out the proposed improvement. So you couldn't just say, oh, I want you to move the cable. There had to be a reason, it had to be necessary because of what you were doing. Again, there was a 28-day process, and if the operator served counter notice in that 28-day period, then the person had to make an application to court. What could the court do? Well, they had to order that alteration, but they had to take into account that people had to be not unreasonably denied access to electronic communications. They had to be satisfied it was necessary. And the one in red was the important one, that, oh, I didn't need to do that, did I? That the alteration wouldn't substantially interfere with the operator's services. And that's why people very rarely use paragraph 20, because to use it, you have to show that what you're doing won't substantially interfere. Now, if you're going to knock a building down and not be able to supply or have the mast on the roof for another year, then you are going to be interfering with the operator's services, unless you can very soon find somewhere else to put the equipment. So it was removing apparatus was the other thing you could do. Talks about lift and shift, you could go ahead and remove. And this was available to a person who was for the time being entitled to require the removal. If you're a person for the time being entitled to require removal, then any tenancy or contract must have ended. And that's why it was really useful to agree termination rights in the lease in your wayleave. There was a problem with leases with security of tenure though. The landlord had to go through the 54 Act procedure if the lease had security of tenure before it would then become a person entitled. I'm going to come back to that, because that's been fixed in the new code. You absolutely couldn't contract out of that paragraph. And there's also no means of checking who used the apparatus, and it was the people who used the apparatus that had the code rights, not necessarily the person who you had granted your lease to. So if people were sharing with other operators, then potentially you had an issue, because you might be thinking, I've sorted it out, and then another operator comes asking for work and says, hang on a minute, I'm using this. So it was very difficult. Let's just focus on the leases and security of tenure position. So thinking about a lease of a telecom mast here. A security of tenure is where you've got a business tenant in occupation, and they haven't agreed to contract out under the 54 Act. Is everybody familiar with that contract process? Brilliant. Continues beyond the contractual end date of the tenant's lease, unless it's terminated according to the 54 Act. So you've got three ways. Once they've held over, the landlord can serve a Section 25 notice to bring it to an end, tenant can serve a Section 26 to continue, or tenant can serve a Section 27 to go. The problem was when tenant wanted to continue or was opposing a landlord's end. So, tenant has the right to request a new lease. This is where the problem comes in. So tenants say, no, I have security of tenure. Landlord goes, that's not a problem, I'm going to serve a Section 25 notice on you. and they do that. But then they think, well, I want to terminate the lease on redevelopment grounds ground F. But it's difficult to prove my intention to redevelop when the lease is code protected. And I can't serve a notice under the code until I've already terminated under the 1954 Act. And I won't get a termination date for the lease until I can prove development grounds under the 54 Act. So I've just got this constant circle of, I can't prove that I can get the tenant out, therefore I can't prove that I'll be able to redevelop, and I can't actually bring it to an end under the code to be able to serve a termination notice under the code. It's just a constant circle. So a real problem if you granted secure leases under the 54 Act. But spoiler alert, that problem is gone. So what happened if you did have a termination date and you didn't have this 54 Act protection? So if you were the person entitled to require removal, you could serve a notice on the operator to remove that apparatus, and there was no prescribed form. 28 days, it's beginning to sound familiar. But the operator could come back and say, no, I still want to continue my service. And then you had to go to court to actually require removal. And what would the court do? Well, it would not make an order for removal unless the operator wasn't intending to or is being unreasonably dilatory in making the steps specified in its counter notice. So if the operator doesn't behave properly at that stage, it risks losing its rights. Or the steps the operator is taking won't secure the right to keep or reinstall the apparatus. So if you've reached a point where, if this was going back to the beginning, the operator had been trying to go through the court to get new rights and they wouldn't have succeeded, then you would have been able to get removal at this point. Again, people very rarely did it. Everything usually went through negotiation. There's very, very little case law on the old code. And the few cases that there are relate to actually more payment and compensation issues. And lift and shift, we have those specific rights under paragraph 20 under the old code that talks about the alteration rights, but we definitely used to insert express lift and shift clauses in our agreements. If the lift and shift actually ended up in a scenario where you needed to terminate the agreement rather than just shuffle around, at that stage we may not have been able to enforce it, but it showed the parties contemplated removal. It was all extra grist to our mill if it ever got to court. And I say, made sure we inserted termination rights, so that if we couldn't agree on a removal, we could at least go through that termination procedure and trigger it. So that's a quick run through of the background. What about the new code powers? The new code powers, this all, like I say, it all came into force on the 28th of December 2017. If you're looking for one place to find everything, it's spread across a couple of schedules of different acts, but actually if you go to the Digital Economy Act 2017 and look at schedules 1 and 2, you've got schedule 1 is the new code, schedule 2 is all the new transitional provisions. And it gives at paragraph 3 a whole host of new code rights. I see these as a shopping list from which to choose. I'm finding some operators are actually saying, under new code, we can potentially have all these rights. So when we're drafting an agreement with you, we're putting in all these rights at the start. I don't think that's the appropriate approach. I think it's a shopping list to be agreed between the parties. So there's install apparatus, and I'm going to shorten that to ECA, under overland, keep it installed, inspect, maintain, adjust, alter, repair, upgrade, operate, carry out works, etc. If I can, I'm personally trying to get rid of upgrade when granting rights, because I don't want to grant a blanket right to upgrade. I only want to give operators the right to upgrade in accordance with the code, and you'll see why I say that later. So I'm trying to take that out of the actual rights that are agreed between the parties. But they carry on. You can carry out works on the land in connection with maintenance, adjustments, alteration, repair, upgrading, inspect, maintain, adjust, alter, etc. Take upgrade out again. Connect to a power supply. That's something the operators were quite keen on getting into the new code, this ability to connect to a power supply. That doesn't mean to say you as a landlord have to provide a power supply, and it certainly doesn't mean that you have to pay for their electricity, but it means that you can't kind of stop them if that is a right that's agreed. And then they get quite serious, interfere with or obstruct a means of access to or from the land. I think you're only going to be agreeing to that with limited parameters and where it's absolutely necessary, and which is again another reason I don't think you should ever be granting a blanket right to do that across the property. And then cut back or lock trees, etc. It's only going to be appropriate in specific scenarios, so don't agree unless you have to. Those are all the new code rights that are available to code operators. Any new code right has to be granted by agreement, and that agreement is either something that's negotiated between the parties, or it will be forced on you by a court if the operator wants to go to court. So that whole process is still similar. Now, it does say the agreement's got to be in writing, signed by or on behalf of the parties, state for how long the code right is exercisable, state the period of notice required to terminate the agreement. And if your agreement does not fall within those four, it won't be a code agreement protected by the code. So I think that's something that the operators will be very keen on making sure happens, because any slip-ups will mean that they lose out on code powers. As landowners, you are quite happy for people not to have code powers. It's also another thing to think about, so I think Stacey, you asked me about tenancies at will. Could a tenancy at will actually attract code powers? The answer is yes, if it's in writing. But if it's not in writing, it's something that's just come about, then it wouldn't satisfy that test. And think about that also where people have been let in and then they've got periodic tenancies, that sort of thing.
So just quick one. So you're saying that if given us these new code powers that come in, unless it's stated in the agreement release, they don't apply?
No, it's not that if it's stated code powers are in the agreement that is applied. It's just that the document that grants the agreement has to be signed in writing, state how long that code right is exercisable. So, in other words, is there a term, or do you know when it's going to finish, hence the termination? I don't think you expressly need to say code powers in that document. I suspect that would be implied in there. It's just got to keep to those four. However, if it's just because it's not a code agreement doesn't mean to say you'll still not have problems getting them off the land. If something is a code agreement, then there are complicated termination provisions that you have to go through. If it's not a code agreement, you can skip the complicated termination provisions and jump to the removal. So I'm going to come back to that.
Why wouldn't they made it registerable?
The old one wasn't registerable, and this one isn't registerable either. I still think all leases, if it's to be registerable as a lease, those and the operators will still register a lease. But what they don't register are wayleaves, which is when you're looking at a deeds packet. So from a lawyer perspective, you've got to go through that deeds packet and double check for orange wayleaves in it. It's really important to keep the wayleaves with the right documentation stored in the extranet on the right place, etc.
So this covers telecoms equipment on the roof, masts and aerials and stuff, and the cable wayleaves as well.
Sorry, I didn't quite hear.
This covers masts and
Yeah.
aerials and stuff on the roof, but also wayleaves for cables throughout the building as well.
Yes.
Right.
The old code did as well. Yes. One good thing is you can't have a tenant sign up to an agreement and then automatically bind you as a landowner to the code agreement this time. It's essentially the person with the interest in land who signs the code agreement who is bound by it, and then deriving title out of it if they're created later. But a tenant can't bind their freeholder unless they have also agreed to be party to it, or have essentially consented and agreed to it. So you don't get any surprise code agreements coming into force. But I would stress, because I'm going to come on to this later, just because you've not got a code agreement doesn't mean to say you still don't have to go through removal provisions. Oh dear, what did I do? Oh, what do you think I did? How do I get back to? Is it there? There we go. So, this is a question for you really. Can I put cable on your land? Code operator says that. And then the tenant goes, sure. Is that going to bind anybody as a code agreement? Two reasons. The first one, it's not in writing. And as far as the freeholder is concerned, they don't need to, even if it was, they don't need to worry. So here we are. Second one, will you sign this document agreeing I can lay cable on your land for the length of the lease, terminable on 18 months notice? Sure, let me sign right away. I'll ask the landlord later. So it's got all the kind of four things in there, and the tenant's definitely bound by that code agreement, but at that point, the landlord isn't. Prescribed forms are on the Ofcom website. There are so many different notices under the code that can be served when people are going backwards and forwards. So every time I talk about a notice, always go to the Ofcom website. If you circulate the slides, there's a hyperlink in that. And there's a whole kind of zip file on the Ofcom website that's got all the notices for all the different paragraphs in there. So, if you can't come to an agreement, what would an operator do? Well, this time they could serve notice to request the code rights on the Ofcom website to get it. Oh, I'm now going backwards. Sorry. Yeah, if there's 28 days without agreement, then the operator can apply to court. And the court may impose and order an agreement. And this is the test that the court is going to apply. The prejudice caused to the relevant person by the order is capable of being adequately compensated by money. So that feels familiar to last time. That the public benefit likely to result from making the order outweighs the prejudice to the relevant person. That feels like before. Then you've got this new thing. The public benefit test has regard to the public interest in access to a choice of high quality communications. So just because there's one operator there already, that doesn't mean you can say you have to use that operator, etc. There's got to be a choice. So that's stretching that kind of public interest test out a bit more than previously. But the good news for us, which you never had before, is that the court may not make an order if it thinks that the relevant person intends to redevelop all or part of the land to which the code right would relate, or any neighbouring land, but couldn't reasonably do so were the order to be made. So if someone's coming to you and asking for a right, and you know you're going to redevelop that property, it's going to be really awkward for you, this is the time where you can make that representation to the court and hopefully rely on that, and you'll be successful. Terms of an agreement which is imposed. It'll be the code rights sought by the operator, subject to such modifications as the court thinks fit. So I think we know that an operator is going to throw everything in there. If they don't seek as much as they can at the start, they won't be able to go back later and seek more. They'll have to start the process all over again. And the court will decide on termination, repositioning, temporary removal rights, etc. There's a whole load of detail in the code. Yeah.
So is this a brand new agreement?
Yes.
Being forced upon you?
This is being forced upon you. So
because somebody code operator wants to put the kids
yes.
on that.
And they'll try to negotiate with you first. You've not been able to come to an agreement. So this is the right that they have in the background as the stick to beat you with, to say, well, if you don't agree to this, I'm going to go to the court, and they're going to try and make an argument to you that the court will grant them what they wanted anyway. So it's easier for all parties to agree it contractually rather than go through the hassle of the court.
Does this happen very often?
No.
Like, yeah.
Well,
no, I mean,
don't know under the new code, under the old code. No.
The telecom operator saying, I must put a telecom mast on your roof now.
No, they don't. They don't, because they just negotiate with you.
Yeah.
Everything is dealt with commercially and pragmatically. It's just, you need to know what's happening in the background, that if you were really stuck and coming to an impasse, be aware of what's in the background, essentially. Consideration, though, will be on and this is where you may get new disagreements happening that didn't happen before. So consideration is on a value to the owner principle rather than a value to the operator. And this is more relevant for leases because you don't get consideration for waivers.
So is that new under the new code?
Yes.
That's the other one.
Yes, the way that consideration gets valued under the new code is very different to how it was in the old code. So for consideration that the court would order, it will be the market value of the relevant person's agreement to confer to be bound by the code right. So you've got a willing buyer and seller, transaction at arm's length, parties acting prudently and with full knowledge of the transaction, and subject to the other provisions of agreement ordered by the court. So far seems so reasonable. But then you've got the assumptions, and you're assuming that the right does not relate to the provision or use of an electronic communications network. So if that's where you would have got the value previously, and that's what would have created the value, the fact that it's granting a code right, and that's what people would have paid for, now you're assuming it doesn't relate to that. You're assuming that powers that the code gives an operator to assign, upgrade, and share don't apply. So all those valuable powers to the operator, you're ignoring that. In all other respects, it responds to a code right, but you're also assuming that there's more than one site which the buyer could use for the purpose which the buyer seeks the right. So say there is only one site, and therefore they can pay a special amount for that site. You're still making assumptions that other sites are out there. Speaking to other people, reckon this may chop at least sort of 40% of the value of consideration that might have been granted previously. I'm the evaluation expert, that's just what I've heard. The court can order a lump sum, periodic, conditional on events or other sums. But the really important things to take away from this are these assumptions, which are new, greater from the evaluation perspective.
Doesn't that make the value virtually nil?
It could do, I think, yeah.
Yeah.
That's the biggest concern.
Yeah.
Yeah.
Which is why we've always had an issue about being put into effect, because it's been going around for ages, and the code operators have been trying to get this legislation to be brought.
Yes, it was. I'm trying to think, it was last year, I think it was last year, it was slipped through in the last minute in a schedule in the Infrastructure Act, and then everybody went, hang on a minute, you can't just at the last minute put this raft of legislation, and then it got removed, and then we had the Digital Economy Bill, and then it later became Act, but it was still not in force. And then at 2 weeks' notice before Christmas, they said, right, we're bringing it into force. And yeah, the code operators have been lobbying. I'm only sort of guessing it's all because of this sort of need to get broadband and telecommunications all over the country, and the sort of public policy push behind that is worth more to the government. So we've got to what consideration will be. There will be compensation for loss or damage that's been sustained as a result of the exercise of the right. Expenses, which can include legal valuation, diminution in value of the land and the cost of the reinstatement. So I do wonder whether the compensation could actually factor in if the land could be used for a different and far more valuable purpose, whether that could actually factor in the compensation. For example, if the code is on land that you're not going to develop for, but it was worth developed as something else, if you see what I mean. In other words, if the code right wasn't the most valuable use you could put that land to.
What's playing out at the moment in the marketplace?
What's
happening in the marketplace as a consequence of this in terms of rents?
I honestly don't know, in that I've not seen any leases actually agreed since that date.
Andrew Cranston is saying that although this is going to come in, people could apply to this. What our argument as a landlord is their main concern is being able to get on and maintain equipment and upgrade it as and when they need to, i.e. immediately. And if they're paying us money, then we're happy to accommodate that. But if they're not, then it doesn't make sense for us to. We can be difficult in terms of not approving rounds, delaying people by a few days. But for that reason, even though this is coming in, I think that the operators are still going to pay the normal rent in a lot of cases. Just to keep that relationship there. Having a good relationship with them is more important than paying a few quid. But my question was, and all of a sudden these new codes rights would essentially mean that's 40 quid. Would it adjust existing lease rental, or is it just new agreements?
That's the transitional provisions with an existing agreement from us, so we'll come on to that. If I don't answer the question, then remind me. So we looked at forcing an agreement on someone. There are also two new things which are interim code rights and temporary code rights. So an interim code right is where the operator serves notice to request rights on an interim basis. Again, 28 days. If no agreement, they are then applied to the court. But this time, they don't even have to wait the 28 days before they apply to court if it's really urgent. And the court may impose an agreement. And this is where the test is that the operator and the person have actually agreed to the order. So you could have in advance agreed with the operator, you're happy for them to have interim code rights, and the court thinks there's a good case, arguable case, that they will get a full code right. Okay? Interim code rights are essentially can be time limited and will stop and won't continue after the end of the agreement, a bit like holding over. So again, just hold that thought that interim code rights can be used in a scenario where you want everybody's happy for them to have an agreement, say for a year, 18 months, but they absolutely want it to stop at that date. The temporary code rights, this is where the apparatus is already on the land. You do have a right to require removal, but the operator serves notice to request temporary rights. So this is fairly urgent again, so they can still apply to court within 28 days. Court may impose an agreement, but they'll only do that if they think it's reasonably necessary to maintain the service provided by the network and the apparatus is properly adjusted and kept in repair pending proceedings to remove the apparatus. So a temporary right will be used where you've got an agreement in place, you've been through the code process to get the equipment removed, which I'm going to talk you through, and then you're about to go through the process to get the equipment properly removed. And in the meantime, we need temporary rights granted to sort of tide us over between applications. This is new, this bit is brand new. This will again affect leases particularly, but it affects wayleaves, anything that is a code right. There are assignment rights, so any new code agreement mustn't restrict assignment to another operator. There is free assignment to someone else who's an operator designation on the code website. Subject to a guarantee agreement. And this is where it starts to feel like an ARGO under the 95 Act. you know, in a new lease granted to a tenant, that tenant assigns, they have to be released, but they can give an authorised guarantee agreement. This is exactly the same. They can give that guarantee agreement, and the assignor will not be liable for breach of the agreement occurring after assignment if it has notified of the assignment and notified the service of address to the assignee, subject to having given that guarantee. Any attempt to restrict assignment is void, save for requiring the guarantee. And the guarantee can't impose liability in relation to a time after the agreement ceases to be binding on the assigning operator. So it all feels like an ARGA. So an operator can freely assign. You can put in the agreement that they have to give a guarantee. Fine, they give a guarantee. They've assigned to the assignee. When that assignee assigns on, you've lost the original operator and you've lost that guarantee, but the second assignee then has to give the guarantee. So you've only ever got the person who's the actual operator on the hook and the one before if they've given a guarantee. Okay, does that make sense? But you can't do anything, so you can't have landlord's consent obligations, you can't have financial covenant strength tests, none of that can apply. Once you've granted it to an operator, that document could end up with any operator. Have I gone too far now? No. The new rights to upgrade or share. The operator can upgrade or share with another operator on two conditions. Changes have a minimal adverse impact, and there's no additional burden on the other party to the agreement. And any attempt to impose conditions on that other than those will again be void. So we can't restrict people upgrading operators, and we can't restrict people sharing operators. We can't require money for them to do that. And do you remember I said earlier, think about your code rights and think about trying to remove upgrade. I don't want to give people a wide right to upgrade. All I want to say is, yes, you can upgrade, but only in accordance with the code and only subject to these conditions. Don't give them a wide right to upgrade. So that's another where the money has gone. Sorry.
Would you say then, if they upgrade, you don't have to compensate you? If you're an operator who's got a dish on the roof of
Yes.
here, for example, it's
I'm going to get my pen out.
it's a small dish, let's say they want double size of the dish. They
Yeah.
have to pay you the double size of the dish.
I think about that.
I don't think so. Not what Andrew said. No. That's a massive problem because we can.
But if it's going to, I'm thinking if it's on your roof and it's going to like go over your roof loadings.
What about that? There's visibility and it's the eyesore and it's.
The other problem as well is we've had operators in our roof cause massive problems, like how they work, all of the roofs cause damage, they interfere with other operators like Metronet. And if with this, if we grant someone to a reputable occupier, 2 years down the line, it could be in the hands of someone with no idea who are absolute rogues who are causing and there's been nothing we can do. So that's another big problem with this code for us.
I'm going to nod and say yes, I think it's a problem. But I've written it down and we'll have a about compensation, etc. That might help. And I just think, I don't know if it's worth having a think about those conditions particularly to see whether those conditions could be used to resist the upgrading. Practical issues. I think actually, that was really a question for you. What practical issues do you see coming out of the ability to assign freely and the ability to upgrade and share? You've already mentioned a couple. Is there anything else from your practical experience that springs to mind where it's been useful to be able to restrict those things in the past?
Does that right to upgrade include additional equipment? So, for example, we don't mention they're not a code operator, but they have a lease of a very small area of the roof, then they have rights to install equipment in certain designated places.
Mm-hmm.
But they have to pay us for each bit of additional kit that they put there.
I was discussing, we had the two barristers from Falcon Chambers in the other day who are writing a full textbook on this, and I was discussing about that, and I don't think they thought that upgrade meant essentially just doubling everything. I think it's upgrading what is there to make it give a better service. But I'm happy to have another chat with them and think about, because I don't know whether putting twice the size of dish on is necessarily upgrading, or whether it's actually putting something a tiny new on. But were you thinking that actually the code did give them that right?
I think where everything else is massively in the favour of the operator,
Yeah.
basically tells them to do what they want.
Yeah.
So we'd be very surprised if, you know, I haven't seen anything in the code that benefits the landlord. It's all in favour of
I know,
the
it's
tenant. So if it is like,
public policy, yeah.
so if it is like they need a big dish to
Yeah.
upgrade, I'm very surprised if there's any restrictions on them doing that in the code.
I'll have a think about it. It'll be one of those things where you know, if you're going to put Dodger Bank on the roof, that's not going to work, is it? And that wouldn't be deemed an upgrade. I will have to think about it.
So our general take on all this is we haven't got a massive problem, but we want to make sure we're properly compensated for it. So we're happy having a reasonable amount of kit on the roof, but provided every time the upgrade equipment does more for the operator, we get paid more for it.
I'm
every
not sure
time-
we will get that. Yeah.
So these are the questions I'm quite keen if you can just get clarity on. And every time they put more kit on the roofs, again, we get really compensated for it. So that tends to be where we get to. There's the odd roof that's got too much kit on there, where we don't want people to put any more on. It's tight, and or there may be some angles in terms of what we're wanting to do redevelopment wise. As a general rule, we're relatively relaxed about having dishes and kit on our roofs, provided we get all the right. There's a series of building space here. Got the right information to get there. Clarification about what we're going to get there.
What about listed?
Try to avoid it.
Doing.
There is kit on some buildings. General rule, we try to avoid that being new.
It's usually on the operator to get permission. It's like M24/7 chooses up to them to get permission, but we just don't check it hard.
So, Serena, they need to go. So, in the case where if we had an operator who get on one of our list,
Like St James's.
yeah. Do they have to, is this all subject to planning boards from strict that at all? Do they just get the full power and
Very good question. I'll look it up, report back. I was just thinking whether the actual wording in the code helps, but I don't think it does. This is good news. New code rights and security tenure. The top of the problem there. So if the primary purpose of the lease is to grant code rights, similar as you putting on telecoms maps, then there won't also be security tenure under the 54 Act. You're just dealing with code protection. If the primary purpose of the lease is not to grant code rights, I'm thinking here you're letting to O2 who've got a retail shop, and it's a retail lease to O2, but there's no one to put sort of kit on the roof. The primary purpose is for the retail shop. And then the code rights won't apply, but the 54 Act will apply. I'm sure there will be some grey areas in the middle where people will be not quite sure, but definitely with the telecoms maps, you're only going to be worried about the code. Continuation of code rights. This expressly continues your code agreement beyond any contractual termination. So as an operator, the agreement will continue beyond the end of the contractual date, unless the code right granted is temporary or interim. So again, remember, granting an interim code right through the court is the only way to get it fixed and coming to an end on that day. The new code termination process is very different to last time, and there's much longer time periods that you need to be aware of. If a landowner serves a code notice to terminate, and again you need to go on the Ofcom website and get the code notice, it's got to be at least 18 months notice, and the end date must fall after the contractual end date of your agreement. The operator then has 3 months to serve a counter notice saying, I don't want to, and I'm refuting the grounds on which you're saying you terminate. If they serve that counter notice, then they've got a further 3 months to apply for cause. So it's hoped that you'd get everything sorted in the 18 months notice that you were given anyway, whether it is a case of, yes, it's terminating or no.
Sorry.
Oh, sorry. Is there any cap on how much notice you can get if you serve notice when you sign your agreement?
Yes, it's at least 18 months. Ooh, so you're thinking They have
So you
to.
could sign the agreement with them the day after, go, yeah, you coming out of it.
I like your style. I don't think so. I will double check though. Time limits are this may spoil you. Can the operator simply serve a new notice requesting new rights if he misses a deadline? So again, if you did that, there's possibly nothing to stop them coming back. And if they have the right to impose agreement, they could do that and they could impose a new one on you.
Just got another
Yes.
one. How do you know which sector? So I find out who the current operator is.
Is that bit? Yeah. it's like you knew what I was going to say. So that was where the contractual end date is in the future. This one is just where the contractual end date has already happened and the agreement's effectively holding over. So say it was today, you could serve a notice to terminate, but you still have to give 18 months in the future. So whether you're before or after the end date, you've still got to serve it. 3 months counter notice, 3 months to apply to court. Okay? So wherever you are in the timeline, 18 months has to be given. Okay, the other thing is that this is quite like the 54 Act. You can only terminate if you can show a statutory ground for termination. So substantial breaches, that feels like the 54 Act, doesn't it? Persistent delays in making payment, again, feels like the 54 Act. Intention to redevelop and can't reasonably do so without termination, again, feels a lot like the 54 Act. What we don't have clarity on is when you have to show that intention. With the 54 Act, you have to show your intention to redevelop at the date of the court hearing, as opposed to when you served the notice. There's no particular clarity, but I think a lot of people feel it will go down a similar route. Or the operator doesn't meet the test, which it would have needed to satisfy if it was going through the process at the beginning. If you can't show one of those 4 grounds, you won't be successful. You can't just serve an 18-month notice to terminate because you want them to go. You've got to show one of those 4 grounds. So the one that I suspect will get used most, if necessary, is the redevelopment one. What will the court do if no grounds are approved? Well, they'll continue the existing agreement for such period as specified as they choose. They can modify the terms of the agreement. They can take away code rights that were previously there. So you had a long shopping list, they can remove some of them. They can have new ones in. They can terminate the whole thing and grant new code rights. So basically, they've got a huge amount of discretion. And the court's got to have regard to all the circumstances of the case, including the operator's business, structural, technical needs, provider's use of the land, duties imposed, etc., etc. So there's a big, wide melting pot that will go into what happens. But what do we do if a ground is approved? Well, the court will order that the code agreement is terminated. And this is where I said at the beginning, you've got to go through this full process of this 18-month process to terminate a code. And that's not the end of it. You think, oh, I've got there. No, you haven't. You've then got to go through another court process to actually get them off the land. So if you end up going through the courts, I think it's probably at least a 2-year process. The conditions to be able to require removal are maybe that your landowner has never been bound by a code agreement. So remember I said at the beginning, if you've got an oral agreement or something like that, you can skip all the termination bit and jump to this bit. Code rate has been terminated in accordance with the code, so you've gone through your 18-month process, the court has ordered termination. The operator does have a code right, but the operator is no longer used for the purposes of the network. There's no reasonable likelihood of that happening. The code has ceased to apply and no other operator held the right to keep it there. I'll come back to your point in a bit. Or actually, if it's neighbouring land that needs to require removal, etc., you can go down that route. So if you have gone through your termination process properly, the court has granted you order for termination, you will satisfy that, and then you need to go through this process. You satisfy the conditions. This time, rather than helpfully, it just says you've got to give reasonable notice to the operator to get out. So what is reasonable notice? Everything else in here has got a strict time period set out. And then all of a sudden we've just got reasonable period in which to comply. However, if in 28 days you haven't come to an agreement with the operator, that's when the owner can make an application to court for the order, removing, reinstating, possibly selling the operator's compensation for loss between termination and removal, etc. So there is an incentive for everybody to get it agreed within 28 days. So it's just a very long-winded process compared to what there was previously. Previously, you gave 28 days notice to go, and then you went to the court process, and kind of that was it. Now you've got this 18-month notice, and then removal. Lift and shift, I haven't mentioned lift and shift up this time, that's because there is no lift and shift right in the new code, but there's no harm in contractually inserting lift and shift right, so absolutely do that. There are rights to request amendment of the terms of an expired agreement, which is continuing under the code. So there's a sort of mini, almost renewal. So say the term of the agreement has come to an end and the parties are happy to renew it, there is a procedure that you can go through for that as well. What is electronic communications apparatus? Could have said this at the beginning or the end, but everything that I've been talking about is listed in paragraph 5 of the code, and it's really, really wide what is electronic communications apparatus. So it's everything that you would think of in terms of masts, cables, etc. But it can also be apparatus which is designed or adapted for the purpose of providing an electronic communications network. And the other day when talking to these barristers, they were saying how some parties go around purchasing tall sort of landmarks, water towers, old gas towers, that sort of thing. And they are literally sitting there waiting for a code operator to come along and want to put its apparatus on their tower and gas pump or whatever. And actually, the very fact that they've acquired that network of infrastructure and they are sitting there waiting for operators to come along almost makes that infrastructure itself electronic communications apparatus. Or if you bought a gas tower and kitted it up with stuff, does that stop being a gas tower and it becomes itself electronic communications apparatus? And this is important because the code only applies to scenarios where the electronic communications apparatus is installed on land. It doesn't apply when you're putting kit on kit. So operator-on-operator agreements are not caught by the code. However, if people are thinking, yay, that stops us worrying about kit-on-kit agreements, it might be still that where an operator is putting kit on another person's kit, they still need all those rights to cross land and rights to run cables that may still be going over land and might involve the landowner. So whilst that seems exciting, it may practically be a bit difficult to get out of the code. So this answers your question, how do I know which operators are using equipment on my land? Well, you can serve a notice. You can blanket hit every operator in the country if you want and say, here are my properties, can you tell me what you've got in there? How they would ever respond if every landowner decided to do that, they would not have the ability to. So you can say, have you got operators there? Have you got a code right in respect of my land? They've got to reply, and if they don't reply, you can apply. What happens is that if you apply to remove the apparatus and it turns out they did have a right after all, it doesn't mean that they've lost their code rights, but it means that they have to pay your costs of essentially what becomes a wasted application. So there is a right to do that, but practically what information you'll get back from code operators, I don't know. Little test for you, after everything we've been through. It feels the new code is quite complicated. So a telecoms operator needs a landowner to sign agreement before they can go onto its land. True, false? I've got falses and I've got trues. Oh no, I've gone backwards. Oh, it's because I'm. What am I doing? Hitting the wrong bit of it. There we go. I said false because you don't need the landowner to be able to go onto the land, do you? So it could be the tenant, it could be an occupier, etc. The code will apply to anyone who wants to make cables on the land. False. Yeah. Because you've got to be an operator. Where the code applies to telecom operators, it will also attract security tenure. Once telecommunication operators is in a property, the landowner can ask for it to be altered. I've said true. You can ask. Whether you'll get there is another question, essentially. And lift and shift will get around the code's powers. It's not going to get around the code's powers, is it? So you can put lift and shift in your agreements. But if that lift and shift means you're going to have to go through a termination procedure, you're going to have to go through everything under the code. Transitional provisions for subsisting agreements. So the new code does apply to subsisting agreements, but with some limitations. You are limited to the rights under the old code, so just because you've got a subsisting agreement doesn't mean that the operator suddenly has all the new rights under the code. They don't. They're still limited to whatever they were granted under the old code. The assignment, upgrade and sharing rights don't apply, so that's good news. Anything agreed 27th December and previous will not automatically apply. Assignment, upgrade and sharing. Leases with security of tenure. I think this is the point that you were saying earlier on in terms of renewal, etc. If you've got a lease with security of tenure that is now in the holding over period, it's essentially the 54 Act that will apply to that lease. So even if it's a lease of a telecommunications mast, the code is drafted such that, because we don't want two sets of things applying. So you've got a telecommunications mast in a holding over period, it's the 54 Act that applies and not the continuation and termination rights under the code. So that tenant would have to go through its 54 Act renewal process and protect itself from there. And in terms of the renewal values, you'd be looking at what it says under the 54 Act for the new rent under that agreement. However, when that new lease does get granted in terms of its future protection, because it's a primary purpose code right, as soon as it's granted, the oddity is that then it will flip into being protected by the code, and all the termination provisions under the code will apply and not the 54 Act. If it's a lease without security of tenure and the primary purpose is not to grant code rights, then still the automatic continuation code-specific termination provisions won't apply. So when I'm saying if something is 54 Act protected, that's good because you only need to worry about the 54 Act, and then you start worrying about the code and get a new lease. If you ended up with a scenario where the lease was 54 Act protected, but the court did grant you termination of the lease because of a redevelopment ground, it might be interesting what then happens about actually removing the apparatus, because the apparatus is there on land and you still have to go through the new code to get rid of that. Complicated. The 18-month provisions for termination of a subsisting agreement don't apply. They're reduced to 3 months, or the length of the term that's left on the document. So if you've already in a holding over period for something, you don't have to serve 18 months notice, just 3 months. If notices have already been served under the code at the point at which this code came into force, under the old code, it's really complicated, but I'm guessing you're not going to have any of that, so nobody's got a live code notice being served, have they? No. I think we've got about 3 in our retired firms, so I just don't think they're that common. Ooh. So, a little case study, just to kind of bring it all back. So we've got our tenant here, and they're saying they need broadband, like at the beginning. We've got this tenant here, who's been there for some time, who's got their cable. You agreed to my wayleave years ago. And we've got the mast here, and the term on my lease expired years ago. Okay? But you want to come along and redevelop the lot. What are your thoughts? Let's say you want to redevelop in 2 years. That's why you've got that tenant saying, I need broadband, you don't quite need tenant, I need broadband. You know you want to redevelop in 2 years. That tenancy there was a short tenancy, it's contracted out, you know you're going to get them out. Exactly. I think the only thing you can do with that tenant is unfortunately agree to go through the court to order an interim right, which is on a time limited right. You need to go through the 18-month termination provision and then the removal, etc. You just won't have enough time before your redevelopment. What do you think of the other issues? How long will that one? If that wayleave was agreed years ago, when it's determinable, say on the tenant leaving, or determinable on 6 months' notice, etc., what's the maximum notice you'd have to give for that? 3 months, or the length on the term of it? Brilliant. What do you think of this one here?
1954 Act, depending on what was within the lease. So if he was a contracted out, then you don't have to, but if he was within that, then you have to leave that business.
Yes, brilliant, brilliant. And those are all live things which I've been looking at and advising people on, well, not just me, people in our team have been looking at what types of notice, how long have we got, what can we do before redevelopment happens a couple of years down the line. And I think the big important ones are going to be the masts and making sure we go through the right process there. I've stunned everybody into silence, horror, boredom, I don't know which. Questions? I've got my pad. Does anybody have any more questions or thoughts on any of that?
If you want rent reviews, you just need to do all the rent reviews, so there's no point going over to market. For a landlord.
You mean for the telecoms mast?
Yeah. Markets can
Yes.
go one way.
Yeah.
It appears.
Yes.
Because
Yeah.
ultimately, even though what Mark says is true, nobody ultimately can put a mask wherever they want to, which is what this is enabling them to do, then this is driving down the market rent because
Absolutely.
the comparables are really so slow.
I was just thinking, is there any way the court wouldn't even allow, if you were forced into it, would the court even allow that? And I don't know, but it would seem unreasonable to not allow something like that. I don't know, I'll think about that.
Most laws are going to
Yeah. All of them. Gotcha.
I think to summarise, what you need to take away from this is new code agreements, be aware of the ability to assign freely to an operator subject to that guarantee, the ability to upgrade and share. I'm going to check how far upgrade we're going to need. So be aware that you just can't get out of those. Be aware of the 18-month termination provisions and the statutory grounds on which you can get out, but you've got to prove one of those to bring it to an end. For subsisting agreements, you've got to be aware of that, but slightly shorter time periods, etc. And then the other thing to think about is actually whether you're ever getting involved, probably not as much for you, but where operators have got kit on kit, whether you need to actually worry about that, because that's a kit on kit agreement and not part of your concerns. But it's assignment sharing, upgrading, length of termination. Those are the 4 things that I would take away from today.
If someone came along and we didn't want them, is there anything we can do to make it difficult or make it unappealing?
I suppose you'd be looking at what were your grounds for saying no, you can't, what, and how strong is their public policy argument for needing to be there. And it's a case of, can you be adequately compensated by money versus the kind of damage to the public interest? Can you create a hole in the argument for them? Or can you show that you're going to redevelop?
Is that compensation a one-off payment, or can it be ongoing? So, for example, I was saying if we have contractors on the roofs and they damage the roof, and we're saying to them, you're effectively causing us to spend capital on our building, which we wouldn't necessarily do. You need to compensate us for that. Can that be ongoing, or would you have to literally just put it in for a one-off amount?
Most agreements contractually would contain provisions saying that they have to pay compensation. My gut feel is that if they're coming onto your land and damaging the stuff, there's got to be provision for them to do that.
What happens when you said about your lifting shift?
Yeah.
What happens if you request lifting shift? They say no, we're not after putting lifting shift in. There would be any case where I have to say which way the call. They say that's reasonable to put it in. Because we need lifting shift, because we do work to our roofs, we need that in, even if it's at 6 months notice. Because they say there's no express rights in the code, so they say no, they don't agree to that, and then we could be forced off someone on our roof that you can't move, and then if we've got a massive leak in our roof, we've got no means to move them.
I'll have a think if there's anything. Understand.
We're not allowing any road storage.
Not at the moment, but with this, someone could
If they assign.
Someone could assign, we could put EE on the roof, and then a year later, there's Joe Bob's on the roof, who's got all his wide boys up there. You know, but some roofs, but we don't have a clue, we do EE. And then,
Well, I'm saying, don't let Joe Bob's wife on the roof.
Yeah, but then I'm afraid we can't stop.
Are you just saying, I'm not letting them?
well, yeah,
Joe Bob's issues, so they have to actually get access. Also problems, therefore we just do landlord. Depends where it plays out, we just get some proper messaging into the buildings to make sure we're managing the situation appropriately, therefore people just don't want to come on our roofs. If you look around most of our cities, most of our markets, there's alternative roofs to go on, just people.
at the minute it's not a problem, because all the operators have got there at the moment, but not the last 8 minutes later. But it's if someone comes out, the only reason it's become a problem is someone comes up to us, serves a notice on us, and makes it, and they go on the roof against. Otherwise, previously we could just say no, you're not going to pay, you're not on, but now they can just go to Platts Court and put it on our roofs, and then they can just say no to lift and shift, and then we're screwed. It's not a problem at the moment, but I can just see it being a problem in a few years.
Let me think about that one. I knew I would go over those questions. But it's all really interesting for me, nothing else, just to hear what problems you're having. Thank you very much. Thank you for your time.
Good. You don't hear that.
Thank you very much for your time.
You okay coming back now?
Yeah. 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 Yes, so Thursday back.
You just did.
Sorry.
You just did as well.
Yeah, it's good. Yeah, doing well.
Yeah, I've been trying to decide that.
Let's see next time. How's your?
In Word, yeah.
Halfway through your holiday, you're like, oh my god, I'm going to do this.
Yeah.
So basically, there's no point in doing it.
No, I can't, you're absolutely right, we don't like, that's why I'm sure we're going to relax the program. Yeah, don't worry, it's fine.
Yeah, there's something. I'm surprised. Because for years, I managed to embrace
It's just
soft
present as
approach.
well.
Yeah.
You're a reinvigorate
I'm still confident.
They won't report. They won't even
Clear that it is.
I haven't anyway.
Because it's complicated.
Yeah,
I know, I felt, just whatever protection you have.
Easily agree to something which gives you a thing, like for example, in the case study, the 2-year tenant result. I said you need to say, okay, you go up. So you suddenly you just go to the plans.
But what's in
we've
that?
had,
Right,
I still feel
You might be
I really can't see how.
Yeah, so-
Not good up in I can see a sort of like,
I'm going to carry on
And I'll
the
keep chasing.
It's like a booster coach.
But then I just worry about what
Have we got to change it? The minute they start to
practically online, so
And you can have some kind of note which isn't completely over someone's head who isn't, famous.
I know you looked at metrics a while.
That was a summarized version. It's still really We've done this, having out. You For 3 months, 3 months, 3 months time,
They are a good operating who was on a building.
I'll just stick it quite last by. I suppose 3. If you think your worst case scenario is they're going to have the right to go through the process anyway. Just wait for 3 months. And we should just test.
Yeah, but don't forget.
It's 2 minutes. It's a reasonable time to review it.
Whereas before, it was an
How are you
income.
Actually, generally speaking, since international deposit, the thing is just and then we had a few team restructuring points. Great leaving. So
over the years,
things are slightly addressed, and so picked up brush building.
Does it vary on that?
Dublin, Caroline, it's been getting lots of
I know,
really affecting me. So good stuff. I don't know, I think July.
I asked them.
It's gone quickly. She will have had a full year. I think that's a lot. I'm sure she went up in July.
She's coming back
I think we're just saying you.
I think it's like
I think you
it's a blue, isn't there?
Yeah.
Oh, that's good. I don't know if you about it.
Everybody's providing comments on it.
That's not back anyway, it seems like it's.
Comments on the draft.
Yeah, I work really closely with you, so.
She was there when I was at.
Using the
Oh, was she?
code of practice. I can see that.
It's like I was constitution after that.
Oh, okay. So this is just a
Yeah, no, like I said, when I was there, I did
I've gone through it. Every paragraph is like, people said this.
So when did you come in?
We do not
And that's the thing, you sort of feel.
They do that.
They
They
have
have
it.
I make Yeah, they don't take it.
I've been here 4 years now.
So again, it's like, it's fine, but it's going to be problems with that, and, it's not
Better.
I think it's very different. I quite like the commercial side of it.
Yeah.
Being able to see things through.
Being more
Yeah,
involved.
I quite like that side. In terms of things like as well.
Thanks again.
Like identifying intelligence.
Yeah, wait, just give me a call if there's any issues.
Those being on all those meetings about that.
So we had one today,
Yeah.
every week, 3 weeks.
So I said, possibly.
When I was in training, I was yeah, I really enjoyed it. So many times I sat in a meeting with your remit. It's just a fascinating business.
Teachers transactional money,
Years ago, the transaction was I think for what it means,
Yeah.
yes.
you seem to know about it.
Yeah. It doesn't ring a bell that it was involved in that process in the past. It's like, very bright track.
Yeah, you was good, you were
Yeah, of course.
Yeah, let's see what gets you.
So yeah.
Thanks again.
Alright, okay. Yeah, good. I tried to call you that.
Thanks very much for being here. Yeah. So you've got like a mountain of questions.
Leave me alone.
Some of the other things are actually.
Yeah, not bad. Trying some questions about.
I'm going to actually quite a lot of this.
Yeah.
That's what
Great.
I
Yeah.
But also,
Oh, yeah.
I keep saying
Yeah.
The way he said it to me was, yeah.
This is what I think.
Yeah.
Yeah.
Yeah, that's a good idea.
I think it's hard, it's really useful for us to try and put together some kind of notes.
Guy is chasing.
We've got that basis.
Like everything.
Like I said, that injury where they've let someone on the roof, and so they said, can you do a threat and they will. They like me.
Robin and I was-
Sorry, no, and they could actually so it's like, well, that's already there, so.
That's fine.
So if we can kind of get things up to
Yeah,
date,
the
give them a note, they leave the things.
Yeah, they've got that.
So you don't let anyone else. Yeah.
As soon as people got stuff on the building.
Have you still seen about the
Well, that's what I mean, yeah, so.
And that was always the case.
Yeah, but it's useful to have some of the development surveyors in the room, building surveyors, so hopefully they will have feed it. Yeah, which I suppose will be other
They just stop
issues as
asking.
well. Yes. So yeah, I think that's it.
So I'll
Thank you
catch
very much anyway. Great. If there's anything else for us, then just let me know. In terms of like clarifying any points. No, I need to. Yeah, anything.
Trying to view from. That's good. Is that why you've got an internal? Yeah. If I did something nice, if I sound like that.
He's in quite a lot of training on this as well for other
So
compliance.
flush with your own self. It was like, oh, good, big weeks. Well, my whole is like a big deal. Then events.
Yeah. You know the code off by heart. I knew what anyway. Yeah, that's true.
If somebody can tell that.
Oh, I'll tell him it's okay, don't worry. Thank you very much for coming anyway. Nice to see you all. Yeah, great. We'll see you soon. Thank you very much.
How do you get out? I suppose is the next question. Is it through that door?
Yeah, just leave that door there, right? Thank you. It's okay, it's one time. Yeah.
You accepted responsibility for all that, honestly.
No.